saying that the last discussion on the crossovers, I don't agree with Dr. Vikramaratne at all, or most of the comments that came from the House. I think anybody who crosses over must lose his seat. You go to the Supreme Court on that. If you confer jurisdiction on the Supreme Court for an issue such as that, you are politicizing the Supreme Court, and that is what we have seen constantly. There hasn't been one decision, well, there has been one, except one. All the decisions have been in favor of the government in power at that time. What has that done to our judiciary? So I don't think that issue should ever go to the Supreme Court. If you are a member of a political party and you come on the strength of that political party, I'm talking about the PR system, your vote primarily is a vote cast for your party. Your election as a member is a preference vote that you get. Therefore, I don't think there is an issue of conscience that even arises in a situation where PR is concerned, because primarily it is a vote for the party, and if the party sacks you even unjustly, you can challenge your membership in the party, and if there has been violation of natural justice there, you might regain your membership in the party, but you must lose your membership in Parliament. Because you became a member of Parliament by virtue of being a member of that party and being fielded as a member of that party. I think it's wholly unethical to continue to remain as a member of Parliament once you lose your membership of the political party from which you come to Parliament. Anyway, that said, and I'm saying it strongly so that I invite contrary opinions in question time and I can answer them as well. First past the post system is slightly different, but then the proposed amendment is that even there you lose your seat, but you can face a by-election. That's a good test, because if it is on a matter of conscience that you lose your seat and you face the by-election, you are facing the people all over again. And you are entitled to have the endorsement of your people and come back to Parliament, and that will vindicate the stand that you have taken on behalf of your people. So either way, I think whether it's FPP or PR, you must lose your seat if you no longer remain a member of the political party from which you were elected. Now, Dr. Vikramaratne laid out broadly the contours of the proposed constitutional amendments that will come in the 19th Amendment. Now, before we talk about those specifically, I think we need to remind ourselves that the election mandate was, the mandate that was given at the presidential election was that constitutional amendments that can be passed without recourse to a referendum will be passed. So whatever that requires a referendum will not happen in the 100-day program. So abolition of executive presidency, now again I am raising another issue of contention. It wasn't a matter of contention until the election or run up to the election. But after the election, it is becoming a matter of contention, and I want to challenge that. Abolition of executive presidential system is a matter that requires a referendum. But only one aspect of that requires a referendum, and that is in Article 32, I think, which requires that the president be elected directly by the people. Other powers with regard to cabinet and in my view even Article 4 can be amended without a referendum, so long as any amendment to Article 4 doesn't impinge on Article 3. Now, the 19th Amendment to the Constitution has proposals to remove those aspects. But because the current president is a person who's been elected by the people, there is no urgency to amend that provision. That can come later. And also because he is directly elected by the people and he'll remain in office perhaps for 5 years, during that period of time, a transitional provision, as Dr. Vikramaratne explained, may come into place only for the term of this president. Certain executive powers may be exercised by him, but that is also on the basis that he has been directly elected by the people. But subsequently, a president, a nominal president, will not be directly elected by the people and will not have a direct mandate from the people, and therefore will not exercise any executive power. Now, on this issue, after the elections were over, we hear some rumblings from the so-called minority communities. I don't like to use the word minority communities, numerically, those who are numerically in the minority, saying that an executive presidential system is good for them and its abolition will be to their detriment. And I beg to differ with that view most strongly. I think in the strengthening of democracy cannot in any way impinge on the rights of even smaller communities. If the strengthening of the democratic institutions and the structure of democratic governance is done in such a way as to ensure the participation of all, irrespective of their numerical strength, then that is the strong point. It is not, shall I say, gambling on electing one or the other who might look after their interest because he or she depends on their votes also to come to power. This we have learnt through experience. It may be true that you need, in a two-party system, you need the votes of communities that are numerically in the minority. But the experience is that that consciousness remains only until the day of the election. Thereafter, it is forgotten. Thereafter, the consciousness, well, they did give me their votes, but I got larger share of votes from the majority community. So I must look after their interest. That has been the rationale generally by almost all executive presidents, bar one. I say bar one because Madam Chandrika Bandaranaike Kumartunga was the only one who actually brought a bill to Parliament to abolish executive presidency, but that too in transitional provision, provided that the system will remain for her term, which was the undoing and cost that bill from actually becoming a reality. Or so the UNP said at that time. Now, we have now come to a point when at every election, people have come to power promising either the abolition of the executive presidential system or cutting down its powers, reforms to the presidential system. And almost as a rule, not delivered on that promise for over 20 years. But now we do have an opportunity where the primary promise, if you want to call it that, or one of the three promises, and the first one at that, was the abolition of executive presidency. And it is for that that the people gave a mandate. And I hope President Sirisena will carry that out. As Dr. Vikramaratne said, the draft has been ready for some time, but various political forces that have delayed this, and we hope it will be presented very soon, and that there will be consensus on that, a large consensus on that in Parliament, and I believe it will be there, and that it goes through, which will fundamentally change the character of the governance structure of this country. And when that happens, perhaps for the first time in many decades, the people of the country will once again regain their faith in electoral process and election promises, which is very, very necessary for democracy in this country. If anyone has any misgivings about presidential system and the protection of communities that are smaller in number, I'm willing to discuss that during question time. The reintroduction of the 17th Amendment with certain modifications as to how the commissions are to be appointed and so on is another welcome change, and I don't think there is any issue with regard to that. One or two comments that Mr. Aziz made, and that finds expression in the draft. The 5 members to be appointed by the Prime Minister and the Leader of the Opposition jointly, I think the new draft says, will be done taking into consideration the pluralist nature of Sri Lankan society, all 5. And there was much discussion on this issue at the drafting stage, and even parties that were opposed initially opposed to the phrase or recognition in the Constitution that we are a pluralist society have now come round and accepted that that can come in place. So that's a way forward. And I want to mention something else. This Constitution, we need a new Constitution for this country. The tinkering with this Constitution is not going to work. I say that because we had a Constitution when the country attained independence, and in that Section 29, there were 2 safeguards provided for communities who may not have had the majority strength. And Parliament was prohibited from enacting legislation depriving any community of any right or status that the others had, or conferring on one community something that the others did not have, and also with regard to religious associations and so on. Now, that was done away with in 1972. It was done away with on the basis that it was the concept itself was parliamentary supremacy, and one of the negative contributions that LSSP made, sad Dr. Vikramaratne is not here to listen to this. Of course, their political philosophy of parliamentary supremacy and legislative sovereignty, that it was anathema to think that there can ever be any prohibition by a constitution placed on Parliament. And so that was removed. And we've seen the result of that. We've seen the tyranny of the majority in the Constituent Assembly. I come from Ilangai Tamilarasu Katchi, which made proposals to that Constituent Assembly, 4 proposals Each one of those proposals were defeated 86 to 14, 81 to 13, like that, by sheer numbers. Very reasonable proposals. The last one was just some reasonable, I mean, they're not even federalism, just some reasonable provisions, and that was simply put to vote and defeated. So we saw the tyranny of the majority, the majoritarianism, and that's how that constitution was enacted, with my party walking out and saying that we don't accept that constitution and we are not bound by that constitution. That situation still prevails. You might have seen the controversy with regard to the attendance of my party leader and myself at the Independence Day celebration this year. After 43 years. Why after 43 years? Because 1972 was the last time we participated in an Independence Day celebration. This year we came without any change having happened, but on the hope and on the promise, and even on that day, a promise that was held out by the President that past mistakes would be corrected. The past mistakes have to be corrected. This is one of the fundamental mistakes that were made. That because you have 75% of the numbers, you ignore the rest and make law that suits you, and the country has seen the result of that. 1978 Constitution is also a constitution in which we did not participate. It was made without our participation, and I think that constitution must go in its entirety, and a new social contract must come about. We have agreed, though, that must happen in a proper democratic space with full discussion, without rushing through parliament or through any other process, and we are willing to have that long drawn out discussion in the next parliament. It is envisaged that the next parliament will convert itself into a constituent assembly as well for 1 to 2 years perhaps, and give the country a new constitution after full discussion, not just by parliament but by everybody concerned. So it is to create, firstly to create that democratic space that we supported this first step of a change, and we support the 100-day program and the 19th Amendment to the Constitution, so that it paves the way for a time beyond June this year, when all communities can sit down together without reference to their size in numbers. Of course, if somebody is 75%, that must count for something. I'm not saying that should mean nothing. That must count for something. But that can never be a tool that refuses to recognize the equality of status of even 1% or 0.5% of the citizens of that country. So there is a distinction. You govern by the will of the majority, that is true, but that is no license to deprive the others of a status that you have. Now that is what happened in this country. You attained independence, or so-called independence, in 1947-48, and one of the first few legislation that was passed by sheer numbers was to deprive a community even the right to vote. Now, can you actually imagine that people who voted at 1947 election lost their voting right thereafter? That was the extent. I thought heckling was was only in that house from which he was expelled some time ago, where he's not lost his old habits die hard. Now, please, you can ask questions, I'll answer. So, even if Tamil leaders supported it, that was wrong. Whoever supported it, it was absolutely wrong. Can anyone, that's the question I'm raising. Can anyone ever today, will anyone stand up and say that that was merely because it was passed by majority vote, that you could deprive a citizen of this country of his citizenship, of his franchise, of his very status in the country? But that was what was done by majority vote. And that is what must never be done in the name of democracy and in the name of majority rule. So, we have come a full circle. I think, as I asked the question today, nobody will say, perhaps bar one, that was right. There is a wide consensus in this country that was wrong. There was a consensus reached by the 80s that what was done in 1956 was wrong. That merely because of majority in numbers, that the language of that community was the sole official language. That was corrected in 1987. When it was corrected, nobody, I don't think anybody contested that. Today nobody contests that. But that was wrong. What was done in 56 with the majority vote was wrong. So the issue is, when you make a new constitution, you must have inbuilt safeguards that prohibit such majoritarian tendencies. In a country where you have different communities live, their numbers may differ in size, but their status cannot differ. They must all be of equal status despite their numbers. True, it will be the fundamental feature of a democracy is majority rule, but that cannot take away the status. And so in some ways it goes back to Ijaz's question as well about, and I think what Dr. Vikramatne said to you is very true. It is only because of majoritarian tendencies the other groups then tend to click together and, express their group rights and so on. So, if we are to move beyond that, we must have it in the system. And so, one of the ways in which this imbalance of a permanent majority and a permanent minority can be redressed, it was in this hall that I gave an example some time ago. Some of you might have been there, so I don't want to repeat that. On the faces, nobody seems to have been here. Well, there was a family which had 4 children. 3, this is not my story, I repeat, somebody else has plagiarized it. 4 girls and 1 boy. And they decided from now on, on school holidays, we'll go on vacation. But how do we decide where to go? The girls wanted to go to the beach. The boy wanted to climb some mountain. They couldn't decide. They said, we are a democratic family. They took a vote and they went to the beach. Next school holidays came about, and the boy said, well, last time we went to the beach, this time we must go climbing mountain. They said, no, we are a democratic family. Take a vote. They went to the beach again. Third time round, they did the same thing. The boy started to protest, refused to eat, what we call unnaviradam. Then they did that again, democracy. Then he started throwing some things in the house around. So that is what happens. You see, if there is a permanent majority and a permanent minority, and if there are issues concerning the communities and their status, their language, their culture, their religion, then the permanent majority mustn't have sway. There must be inbuilt safeguards. One of the ways in which that can be done is that those minorities may be majorities in certain areas, and then you devolve power, you share state power in such a way that at least in the areas in which they are a majority, they can have a say over some of the matters that affect their life. So, such arrangements must be made. 13th Amendment or whatever was one attempt, a failed attempt, I would say. But we must relook at that, recognize that it's a pluralist society, I don't think anybody here will argue with me on that. And that then if that is the case, and if all of us are equal in status, how do we give expression to that despite democracy and majority rule? How do we give expression to that equality in status in the governance structure? And that is something that we need to discuss more openly, more forthrightly, take time beginning June this year. Thank you very much.
Knowledge Box, the value-based media network.